webinar, the fourth installment of our Caribbean Africa Trade Series, which started about 3 weeks ago, with the intention of sensitizing both regions, trade, business, students, anyone who has an interest in promoting Caribbean-Africa relations, an opportunity to learn from each other and possibly draw lessons, especially in the context of an AFCFTA, which is unfolding as sort of the new kid on the RTA block. My name is Dr. Yves Remy. I'm Deputy Director at the Shridath Ramphal Center in the Caribbean of the Cave Hill campus. And my co-facilitator is Kholofelo Kugler, who affectionately I just call Kholo. And we've been sort of facilitating these sessions together. We have been assisted in terms of sponsorship and collaborations with other trade centers and trade-related sort of initiatives in Africa, as well as in the Caribbean. And let me just mention, we have tralac, trapca, Afronomics Law. And in the Caribbean, we also have the center, the PJ Patterson Center for Advocacy, based out of Mona. So we're in pleasant company. Today, after hearing last week about the goods and services and IP regimes, we're going to turn to quite a topical issue now, which is investment and investment regimes in Africa and Caribbean context. Investment now is hugely important, especially in the wake of COVID, where as a result of these halting of the economic activities in many countries, we saw dips in the World Trade reports of, in some regions, up to 20–25% of investments. We have now rethinking about post-COVID, how industrialization and industrialized sectors will rethink approaches to investment, both in terms of attracting a greater source from the traditional FDI, focusing possibly on more regional and local investment across Africa and the Caribbean, but even looking at new sources, possibly looking, in our case, to Africa for more investment, and Africa looking to the Caribbean for different types of investment as well. We know also in the context of the SDGs, the Sustainable Development Goals, a huge part of that piece is how are we actually going to sustain and fund attainment of these goals. We also have, in the context of COP26, a discussion about the Green Climate Fund and who's going to invest in these new technologies. So investment has somehow become a huge issue that's going to be relevant. And today we're going to hear, I think, less about these broader sort of macroeconomic forces, the wait to hear, but more, I think, deliberately about the types of regimes that have been crafted in Africa, being discussed in the context of the AFCFTA, but a longer running process in CARICOM about how we ensure sustainability in our investment approaches, but also how we think about creating harmonized approaches so that we're not competing with each other in these regional contexts for investment. And Kholo is going to introduce our speakers, but let me just say how happy we are to be able to bring this fourth investment to you. And without further ado from me, let me hand over to my co-facilitator, Ms. Kugler, to introduce our wonderful speakers today. So Kholo, on to you.
Thank you, Jan. It really is a pleasure for me to introduce our august panel. The first is Dr. Chantal Ononaiwu, who's the Trade Policy and Legal Specialist at the CARICOM Secretariat, where she advises the community and its member states on external trade negotiations and other matters pertaining to international trade and investment. She has served as negotiator for CARICOM in its external trade negotiations and has represented the community in cases before the Caribbean Courts of Justice. She is a lecturer in international trade and investment law and has also lectured public international law at the University of the West Indies. She's admitted to practice law in Jamaica and Barbados, and she is the President of the Caribbean branch of the International Law Association and a member of the International Law Association Committee on Rule of Law and International Investment Law. Secondly, Professor Makane, who is a professor of international law at the Faculty of Law at the University of Geneva and the director of the Department of International Law and International Organization. He's also an affiliate professor at St. Paul in Paris School of Law. He's been the president of the African Society of International Law since 2017. Professor Beng acts as counsel in disputes before international courts and tribunals, in particular the International Court of Justice, and in investment cases as an advisor for government. He's involved in the negotiations of several international investment agreements in Africa, and he was the lead expert in the African Union for drafting and negotiating the Pan-African Investment Code, the PAC. And he's also finally involved as an expert of the AFCFTA Secretariat in the current phase 2 negotiations in the Future Investment Protocol. It's my great pleasure to have you today. Thank you for coming. And without any further ado, I'd like to invite Chantal for her interventions, please.
Thank you so much, Jan and Kodo, for those very kind introductions. I'd like to thank the organizers for putting together this wonderful series. And of course, I have to acknowledge how pleased I am to be sharing this panel with my fellow speaker, Makane. Today, my intervention will really address 3 areas that are related to the investment regime in CARICOM. Firstly, I will say a little bit about the existing governance framework for investment in the region. And then I'll talk about the ongoing efforts which have been underway for some time to create a single investment space in CARICOM to essentially deepen integration in this area. And thirdly, I will speak to the efforts that CARICOM countries have been making to make investment governance more sustainable development oriented, and the importance of efforts like these to sustainable and resilient recovery from the current crisis we are experiencing. So to start, I'm going to say a few words about the governance framework for investment in CARICOM. Now, as you can appreciate, foreign investment is governed in the region by various tools, domestic law, investor-state contracts, and a range of investment treaties. So when we talk about the governance framework, we're really talking about this mix of instruments. And a range of domestic laws apply to foreign investment. They often address in the region areas such as incentives, but they can cover areas like acquisition and lease of property, increasingly in some countries, special economic zones. They may even govern matters like the obligations that investors have on various matters like taxation and labor. And a few countries in the region, here I'm thinking Antigua and Barbuda, Guyana, Haiti, Suriname, and Trinidad and Tobago, they have dedicated investment laws. If we look at Guyana's Investment Act, for instance, it elaborates the rights, the obligations, the guarantees of investors, and importantly, both domestic investors and foreign investors. And these guarantees include non-discrimination, again, afforded to both domestic and foreign investors, and various standards of protection, access to dispute resolution, and importantly, obligations that investors have to adhere to domestic laws, including health, safety, and environmental laws. And so the governance framework in a number of countries is very much already settled through domestic law. But of course, governments may choose to conclude contracts with particular investors, and these contracts are also going to set out the parties' rights and obligations with respect to the operation of a particular investment. Now, this what's interesting is that there's a third layer of governance that accompanies domestic law and investor-state contracts, and that's treaties, investment treaties. Now, within CARICOM, there are no bilateral investment treaties between individual CARICOM countries. This is something which clearly distinguishes the region from Africa, but there are no bilateral investment treaties between individual CARICOM countries. What we do have in place, however, are the revised Treaty of Chaguaramas that establishes CARICOM, including the CARICOM Single Market and Economy, and in the case of the OECS, the Protocol on Eastern Caribbean Union to the revised Treaty of Bastia. And both of those regimes provide various guarantees that actually facilitate cross-border investments in CARICOM and in the OECS. In the case of CARICOM under the revised treaty, these guarantees are actually quite far-reaching, and they actually go beyond, in many respects, guarantees that most countries in the region which have concluded bilateral investment treaties with external partners have. And the far-reaching nature of the obligations, which I'll touch on briefly, it's reflective of what the level of ambition is. It's, in the case of CARICOM, to create a single market and economy. In the case of the OECS, it's to create an economic union. And so under the revised treaty, community nationals enjoy the right of establishment. That's really the right to create and manage economic enterprises throughout the community. And countries that participate in the single market arrangement, they've committed to remove restrictions on community nationals exercising this right. So restrictions, for instance, on the movement of their managerial, their technical, their supervisory staff, restrictions on setting up agencies and branches and subsidiaries of companies in CARICOM. All of these are commitments which have been made to ensure that there can be the free flow of enterprises throughout the region. And importantly, there's work underway to buttress this right of establishment with respect to harmonizing laws that govern economic enterprises in particular companies. Now, in addition to this right of establishment, community nationals also enjoy the right to free movement of capital. So various restrictions on the movement of capital payments really are meant to be removed as well. And importantly, when community nationals are seeking to exercise these rights, the rights of establishment and the free movement of capital, there are further guarantees that have been given that they're not to be discriminated against on the grounds of nationality, and they're not to be treated any less favorably than nationals of third countries. And additionally, and I know tomorrow's webinar is, well, the final webinar will be addressing dispute settlement. You know, persons given these guarantees are able, with the permission of the Caribbean Court of Justice, to seek redress before the court if their rights are not respected by either member states or the community. So essentially, there are guarantees via adjudication that these rights can be respected. Now, in the case of the OECS, the protocol to the revised Treaty of Bastia, it also guarantees the right of establishment, and it envisages that capital markets will be integrated and fiscal incentives will be harmonized. So that's really a snapshot of the treaty regime that obtains within the region, at least for countries participating in these two economic integration arrangements. Now, of course, another part of the treaty framework is the arrangements that have been concluded with external partners. So a few of the community's external trade agreements, they feature investment provisions, and all CARICOM countries except Montserrat have signed at least one bilateral investment treaty. Some of the trade agreements that the community has with Costa Rica, Cuba, the Dominican Republic, they feature investment protection standards. They allow investors to initiate arbitration against host states in the event that these standards are breached. The economic partnership agreements that CARIFORM states have in place with the EU and the UK, they have limited investment provisions, but what's striking is they are sustainable development oriented provisions that require, for instance, that domestic standards won't be lowered in order to attract investment. And they are also provisions that encourage a certain standard of behavior on the part of investors. Now, where the bilateral investment treaty is concerned, I'm not going to spend a lot of time on this, but I do want to register a couple of points. One, the extent of participation of CARICOM countries in bilateral investment treaties, it varies widely. On one end of the spectrum, you have countries like the Bahamas and St. Kitts that have only signed one of these treaties, and they're not in force. At the other end of the spectrum, you have countries like Barbados, Jamaica, Trinidad and Tobago that have signed more than 10. Few of these bilateral investment treaties are with African countries. Barbados has a bit with Ghana. Jamaica has bits with Egypt, Nigeria, and Zimbabwe. And interestingly, none of these agreements are in force. None of these bits with African countries are yet in force. And the majority of these bilateral investment treaties, and this is a point I want to stress, they're older generation treaties. They're very much focused on investment protection. They have very uncircumscribed standards of protection. They're very broad in scope. Just about any asset that qualifies as an investment is protected. And they provide guarantees to this very wide range of investors to investor-state arbitration. And bear in mind what I've said before, that this is a layer of protection that exists over and above what obtains under domestic law. There are a few exceptions. So Brazil has concluded cooperation and facilitation investment agreements with Guyana and with Suriname. And these agreements are really in contradiction to the other bilateral investment treaties because they promote responsible investment. They don't protect all forms of investment. They're very much focused on foreign direct investment. They feature very proactive provisions on promotion and facilitation of investment, and they don't provide for investor-state arbitration. What is striking is that over the past decade, CARICOM countries have the activity with respect to concluding these bilateral investment treaties, it has slowed considerably. And I don't think that's accidental. It also reflects global trends with respect to the slowing of activity with respect to the conclusion of these types of treaties. I think it's partly a reflection of countries in the region recognizing increasingly that this additional layer of protection that these treaties provide may not necessarily be, may not be needed in all cases. They recognize that these treaties aren't the sole driver of investment decisions. And so increasingly what countries in the region have been very much focused on are measures that would actually improve the investment climate domestically, measures that would improve facilitation of investment. Doing things like setting up information portals, making it easier to establish a business, streamlining administrative procedures, amongst other things. I think that's more and more becoming the preoccupation of countries in the region. And that leads to the second area I'm going to touch on, which is the efforts that are underway in the region to promote CARICOM as a single investment space. You may ask yourselves, well, why is this necessary if you've already guaranteed community nationals rights of establishment? You already can, you know, you've given guarantees of free movement of capital. How much further do you want to go? Well, it's recognized in the revised Treaty of Chaguaramas that further action is actually needed to truly create a single investment space. And so there's a commitment to establish a community investment policy. And the rationale is that, you know, diverse policy frameworks across pretty small economies may not be as attractive as a single investment space that's based on similar investment policies. And so the idea, it's very ambitious and it has proven to be quite daunting, is to tackle areas like harmonizing investment incentives. And Jan in her introduction noted that, you know, in this space, we really shouldn't be competing with each other. But the reality is that we do. And so what has proven to be quite difficult an endeavor is agreeing on a revised or further system for harmonization of investment incentives. Another core component of the CARICOM investment policy framework will be a CARICOM investment code, which is, it's called a code, but it's really an intra-regional treaty arrangement that would create a common regime for the protection, promotion, and facilitation of investment in the community. I'm not going to say a lot about the code, but I just want to stress a few points. One, very importantly, an express objective of the code is promoting, protecting, and facilitating investment investments that foster the sustainable development of CARICOM countries. And what that means is that the code is more likely to be circumscribed in scope than some of the older generation treaties that I spoke about. Importantly, it will build on the existing guarantees that community nationals have and include guarantees that relate to the treatment that investments of investors of CARICOM countries would receive throughout CARICOM. But very importantly, it's going to tackle issues like promoting responsible investment. It will tackle issues like, again, ensuring that domestic standards, the standards countries have set for themselves, are not lowered in order to attract or incentivize investment. And again, importantly, because again, the aspiration is to create a single investment space, it will place emphasis on investment promotion and facilitation by encouraging measures that actually lead to improvements in the investment climate and encouraging cooperative efforts to promote and facilitate investment flows. And in this regard, I'd want to highlight the important role that the Caribbean Association of Investment Promotion Agents, or CAIPA, actually plays, because it already works to promote collaboration amongst investment promotion agencies in the region in areas like joint promotion of the region as an investment destination and improving the investment climate, the business climate in the region. And so work on this community investment policy, it really forms part of a set of initiatives that are meant to provide a supportive macroeconomic policy environment for the CSNE. And so their companion measures to this community investment policy, like a CARICOM financial services agreement to try and integrate financial services markets in the region, and also policies to develop securities markets. Now, I wanted to end by briefly talking about the efforts towards sustainable development-oriented investment governance. As John mentioned, the pandemic has hit the region hard. Probably Guyana is the most notable exception. Most countries have registered declines in FDI flows. The pandemic has highlighted a number of vulnerabilities we have in the region, FDI being concentrated in a few activities. We're not as connected as we need to be with the world economy from a transportation point of view. And so governments are actively trying to figure out, how do we build back better? How do we pursue investment opportunities that will build our resilience and support our sustainable development? And what I just wanted to stress in closing is the importance that the governance framework for investment has to play in these strategies towards resilience and sustainability, sustainable recovery. Again, we must appreciate the importance of our laws or contracts that we conclude, or treaties being supportive of sustainable development outcomes. And I'll just end by saying a couple of things about the treaties. Of course, as I said, we have been slowing down, I think, many CARICOM countries with the negotiation of investment treaties. But what's very encouraging is that the newer treaties or model text or agreements on the negotiation are more sustainable development oriented. There are 4 CARICOM countries, for instance, that are participating in the WTO structured discussions on investment facilitation. And Dominica and Grenada in particular have been advocating for elements in this framework that are supportive of sustainable development outcomes. And I just want to end with a point that I've been making for a while because of the importance of this. Part of this has to involve reviewing our existing treaties, assessing their compatibility with development agendas and imperatives, and determining once they're reviewed if various reform options need to be pursued. So I would just end here. Thank you for your attention, and I'm looking very much forward to hearing what my colleague Makane will have to say. Thank you.
Thank you so much for that, Chantal, and you've done it beautifully in exactly 20 minutes. So I think it'll be really interesting to hear Makane's take on how much the African protocol that he's developing and worked on developing mirrors CARICOM's approach, the points of departure. But as he reflects and as he presents his, Chantal, one of the questions I have is the emphasis always is on, in our minds anyway, on these big foreign investors that will come from outside and invest in our little islands, and that way kind of generate the growth and the sustainable development that we are thinking about. To what extent I think that is tracking the feeling in Africa with the FCFTA that we have to source internally first, and we also have to focus not necessarily on these big investors, but on the small MSMEs. Is that captured when we think about the regime for investment or the diaspora, or just sort of non-traditional approaches to investment and investor-state kind of relationships? How much of that is really kind of seeping down into the mindset of our governments and policymakers as we think about investment post-COVID and the great opportunities, but also the great opportunities in new spaces? So I think ultimately in the Q&A, that's kind of something that I would want us to take up, and how much attention on the architecture of investment has over the past 20 or so years really bottomed out, or has it actually reaped rewards that can match the emphasis we place on the negotiating of these agreements and the putting in place of the frameworks? Like, is it that we realize where our emphasis is wrong? I know you talked about the governance is more important than the legal frameworks, but it's really a point of inflection now, I think, for us in this, as we think about new ways of doing investment. So let me just ask Makane to introduce the African experience, and then Kolo will take it from there after Makane has given his remarks. Thank you.
Thank you so much, Jean-Yves, and thank you also, Kolo, for the invitation. It's a great pleasure to be here. Greetings to everybody, and it's also a great pleasure for me to share this webinar with my dear colleague and sister Chantal, and I appreciate it very much. Presentation, because I think, of course, that there's a lot of convergences with what is being done in Africa. But allow me maybe just to start by saying that in the last few months, we've been witnessing a lot of important shifts regarding the investment regime at the global level. We have seen Asia Pacific countries concluding the regional comprehensive economic partnership that is focusing on investment cooperation. We've been seeing also the draft text of the CAI, the Comprehensive Agreement on Investment between the European Union and China, that is very much insisting on investment facilitation, but for sustainable development with provision on climate change, etc. We've been also seeing the EU concluding an investment agreement with Angola that is mostly about investment facilitation, so something closer to the Brazilian approach than to the traditional EU investment protection approach. We've been seeing Spain concluding a bilateral investment treaty with Colombia where there's no ISDS, where they are actually, referring to the future permanent multilateral investment court if one day such a court is established. So we've been seeing a lot of, major shifts in the investment regime, very, very interesting shifts. And I think that, of course, this is a good opportunity. This is a huge momentum, also not only for the Caribbean, but also for Africa to contribute, to bring its voice, in those important shifts that the investment regime is witnessing. And of course, the future investment protocol to the AFCFTA can play the role of a tool that can also, bring an African voice, an African approach to the reform of the investment regime. As Kolo was mentioning, the AFCFTA process is based on two phases. We have already finalized the first phase, which was dealing with trade in goods and trade in services, and we are now entering into phase 2 of the construction of the AFCFTA. That is about, investment, intellectual property, and competition. And it is in this context that very, very recently we have actually launched the negotiations process of the investment protocol to the AFCFTA. There has been some delay because of the pandemic The negotiation should have started already last year, but because of the pandemic, there has been a lot of delay, and it's just, you know, few weeks ago that the negotiation process has been officially launched, and the hope is to conclude to conclude the deal, the investment protocol, by December. I don't know how successful we will be to conclude such a deal in such a, you know, short period of time. But this is definitely a big momentum for Africa, you know, to come with a mega investment regional with this future investment protocol to the AFCFTA. But it is an opportunity, but it is also a risk. It is also a risk for the continent, because experience has shown that when we try to engage into investment integration, so when we try in Africa to integrate investment policies, it's not that easy. It's not that easy. You know, at the continental level, we tried already with the Pan-African Investment Code. You know, I want to insist that it's not the first time that we're trying to have a continental binding legal instrument dealing with investment at the continental level. There was the experience of the Pan-African Investment Code that was launched in 2012, finalized in 2015, and we all know what was the result. The member states at the end preferred to adopt the Pan-African Investment Code as a model rather than as a treaty. So you would go read the text of the Pan-African Investment Code, see that it is written as a treaty that was supposed to be subject to ratification and so on by the member states, but at the end it was adopted simply as a model because of, you know, the difficulties in really trying to find consensus on how to integrate investment policies at the continental level. But you have the same difficulties. You have the same difficulties at the sub-regional level. I'll come back to that. But you know, we have regional economic communities in Africa, and at the level of some of those regional economic communities, when they tried to integrate investment policies, it was not always successful. Just think about the COMESA, the Common Market for Eastern and Southern Africa Investment Treaty of 2007. It never entered into force. It was concluded in 2007. It never entered into force, and it's in 2017 that they renegotiated it and concluded a new COMESA investment treaty. So we see that difficulties are there, difficulties that you find in other parts of the world, because just think about Mercosur. You know, Mercosur, I don't know, I think that they are now at the third version of a Mercosur investment agreement, and they're still not successful. So I think there is a need to distinguish between trade and investment. Countries in most of the developing world are quite successful in integrating trade policies, but when it comes to investment policies, it becomes much more sensitive and it's not easy. So the investment protocol to the AFCFTA is an opportunity, but it also at the same time a risk that can actually undermine the integration efforts that we are trying to achieve with the AFCFTA. So what are the challenges? In my view, we need to think about challenges. We should not just think about outcomes, having a nice, you know, treaty or nice legal instrument. This we can do, but we need to think about the challenges that we need to actually overcome to have an instrument that will be afterwards effective and that will be implemented by the member states. For me, there are three main challenges when you think about the African context, and in particular, the negotiations of a future investment protocol to the AFCFTA. The first challenge is reducing the fragmentation of the investment law landscape in Africa. For me, that's the first challenge. The second challenge is consolidating the reform efforts towards, you know, sustainable investment. And then the third challenge for me is to reboost what we call the Africanization of the investment regime. Let me start with the first challenge, which is reducing the fragmentation of the investment law landscape in Africa. As I was saying, in Africa, we have several regional economic communities. We have actually 8 of them. You know, in the north, you have the Arab Maghreb Union, then you have the community of Sahel-Saharan states that we call the SENSAD, Then in the West, you have the Economic Community of West African States. Then in Central Africa, you have the Economic Community of Central African States. Then in East, you have the East African Community. Then East-South, you have COMESA, Common Market for Eastern and Southern. And then South, you have SADC, Southern African Development Community. And then in the Horn of Africa, you have IGAD, the Intergovernmental Authority for Development. So you have these 8 regional communities on the continent. And each of them, almost each of them, are actually adopting investment initiatives. Almost each of them. Some of them go for hard law approaches, so adoption of binding instruments that are opposable to their member states. You know, just think about SADC. SADC since 2006 as a SADC protocol on finance and investment. COMESA, as I told you, tried in 2007, has now tried again in 2017. Let's see what will happen. ECOWAS, since 2008, ECOWAS had already a supplementary act on investment that was binding upon its member states. And now in 2018, ECOWAS has adopted a new text called the ECOWIC. It's the ECOWAS, you know, Common Investment Code that is supposed to be binding approaches. And besides those binding approaches, you have, you know, regional economic communities that go for soft law approaches, so models. SADC has a model, since 2012, has a model bilateral investment treaty template. The East African Community has also a model model investment agreement. SADC has actually even revised its model investment agreement since 2016, sorry. So what does it mean? It means that you have this landscape that is actually very fragmented. And I'm not even mentioning, as Chantal has very rightly done so, I'm not even mentioning, you know, the bilateral investment treaties that our member states are concluding among each other, but also with external partners, non-African partners. I'm not mentioning the national investment legislation. I'm not mentioning investment contracts, because then I would just, you know, make the whole landscape, you know, super fragmented. But just if you look at the regional landscape, it's fragmented. So yes, there are convergences, but there are also a lot of divergences on how, you know, investment flows should be regulated over the continent. So what does it mean? It means that, you know, the first challenge of a future investment protocol to the AFCFTA will be actually to defragment the investment law landscape. If we are not able to adopt a protocol that can actually lead, you know, to more convergences, that can actually really defragment the investment law landscape, then what does it mean? It means that we are just adding another layer of complexity. Then the future investment protocol would just be another layer of investment regulation that will come and aggravate or exacerbate the fragmentation that is already characterizing the investment law landscape. So one of the challenge of that protocol is not just to come and say, look, we have a nice protocol. No, the protocol will be efficient if it is successful in, you know, bringing all the regional economic communities, why not even national investment legislation, and to a certain extent bilateral investment treaties, to actually now align with the standards, the principles that are in the future investment protocol. Otherwise, we're just adding more, you know, legal unpredictability, and we make the African market more, you know, less appealing, because as we know, you cannot create a favorable investment climate when the legal landscape is totally fragmented. Let me now come, Madame la Présidente, to the second challenge that I call the consolidating the reform efforts. Here also, I want to actually jump back on what Chantal was saying, and I think that these are very strong convergences between the Caribbean, between CARICOM and African Union, but also the African regional economic communities. You know, sustainable development, formulating investment rules and principles that are oriented towards sustainable development. This is what we've been doing. This is what we have been doing. I can even say, without exaggerating, that Africa has been at the forefront. Africa has been at the forefront of reforming investment agreements for sustainable development. Even before UNCTAD started to talk about, policy investment making for sustainable development, we were already going there. Since 2007, 2008, 2012, African countries were already getting at the regional level into, the need of having a new generation of investment agreements or a new investment regime that is more sustainable development oriented, that is more focusing on investment of quality, as Chantal was mentioning. So we've been, at the forefront of investors' obligations, environmental obligations for investors, anti-corruption obligation. We even invited social political obligations, because in Africa you have a lot of foreign investors that are involved, in coup d'etat or internal or intervention in the internal affairs of states. So we've been very much insisting on the sustainable development dimension, and it's at such a point that I can reveal something to you. When we started the negotiation process of the future investment protocol to the FCFTA recently, there were actually discussions on whether the future investment protocol should be called the sustainable investment protocol. It's just to show you how the idea of sustainability integrated investment is very present. There were discussions saying, well, maybe we should call the future investment protocol to the FCFTA the sustainable investment protocol. Then it was quite complicated. It was quite complicated to reach a consensus on that title, because Article 7 of the AFCFTA does not call the future investment protocol sustainable investment protocol. It just called it investment protocol. So there were doubts among member states that this might go against the black letter of the FCFTA. But it's just to show you how important it is. But this sustainability is actually a challenge now for us. It's actually a challenge for us. Why? Because, the future investment protocol to the FCFTA is supposed to cover intra-African investments, not just any investment, but intra-African investment. The idea is to, how do you call that? To boost and foster intra-African investment flows. But what does it mean? It means that we might have a future investment protocol where you would have sustainability provisions that are now going to be imposed to African investors and investment, while the other ones, the non-African ones, when they get to Africa, they are governed by treaties, bilateral investment treaties, where you don't find these sustainability criteria. And this is a huge problem. And I can tell you already, without mentioning countries that are raising it, but some countries are saying, yeah, but what is this? What is this idea of a new investment protocol where African investors would be subject to more restrictions than the non-African investors? How does it make sense? How does it make sense to go in that direction? And we have seen the battle around, the African Union Declaration on the risk of ISDS related to COVID-19 measures, where the idea was like, let's suspend investment arbitration, let's suspend ISDS. And some African countries say, no, why would my investors wouldn't have the right to initiate arbitration in Africa, while the non-African ones would have the right to initiate ISDS? So this is going to be a huge challenge, making sure that the future investment protocol actually consolidate the reform efforts and not actually go backwards. And then just to finish on the last challenge that I mentioned, which is reboosting what I call reboosting the Africanization of the investment regime. The Pan-African Investment Code, even if it failed to be adopted as a treaty, was a very important momentum. I had several times discussion with Chantal, who actually told me that inside CARICOM, they've been looking a lot, they've been taking a lot of inspiration from the Pan-African Investment Code. I think it was a big momentum because it allowed an African voice. It allowed Africa for the first time to appear as a rule maker in the investment regime and not just as a rule taker. So there was like strong Africanization. Now the problem, what we are seeing today, is that there are a lot of divergences there are a lot of divergences. Just think about investment facilitation. African countries are not going in the same direction because of the negotiations in the WTO. They are not agreeing. It's a problem. Just think about ISDS. I've been reading in some places that people are saying that Africa has the same vision of how we should reform ISDS. I don't know what these people are talking about. It's not true. It's not true. There is not one African position into the UNCITRAL Working Group 3 discussion. So what does it mean? It means that this Africanization, this Africa as rule makers is being threatened today. And the investment protocol has this challenge of, either succeeding in bringing back a real African voice to the investment regime, the reform of the investment regime, or not being able, and we know what would be the consequences for that. So this is what I wanted to share here, those challenges, and I'm very looking forward to the discussion. Thank you very much.
Thank you so much to you, Chantal and Makane, for your interventions. And I think something that really jumped out at me as Chantal's intervention was how the CARICOM is working hard to do away with this race to the bottom type of investment policies, where each country, small economies are competing for investment, which is something, as Makane has highlighted, is something that is actually very much live on the African continent as well. Very similar economies, very small, non-competitive, but fighting for the same investors. And obviously what CARICOM seems to have gone a little bit further, and it seems, more and more successfully than African countries, is this concept of a single investment area, where I don't know if it's going to happen in Africa at all, because I think what Makane has highlighted at the end was the fact that there's a divergence of views. And, for example, you have South Africa that has its own investment code that really has rejected ISDS and has domesticized, the investment disputes. And we have other countries that are completely open to ISDS. So I think this concept of trying to get a single investment code in Africa is going to be very, very difficult. But what I have heard through both interventions, that this concept of sustainable development is front and center of investment, which I think this is a step in the right direction. So I think in addition to Geneva's question, I have a question to Makane as well. So Geneva talked about this concept of what are both regions doing to encourage or to think about different types of investment, looking internally, looking as to the involvement of MSMEs, looking at the involvement of smaller companies and not just the MNEs, especially in this context of COVID, where both regions have been hit very hard because, the whole world suffered, and because our economies are very, very much dependent on outside investment, we probably suffered the most. And so so that was Jenny's question. My question here is, how did, maybe we're hearing from Chantal, is there really a common view coming from CARICOM? Because from your intervention, it seems like there's very much an agreement, or at least tacitly, that this is how investment should be regulated and sort of, managed in the CARICOM region. So what were the steps that brought the CARICOM countries to that level? And from your side, Makane, what is it that this new protocol can do further than what we have in the PIAC already? And are we negotiating this, investment protocol with the PIAC as a model, or is this something that is being brought in that's completely different and new and innovative? So those are my two questions to you.
Kholo, before we invite the experts to answer, I'm just cognizant that we really have 10 minutes left, and I wanted to also just throw in there a couple of the questions that came up in the Q&A. So just to add, as our experts are thinking, one is, there seems to be a lot of questions around where we get information about these regimes. And this is not, exclusive to this forum. It's sort of like, where do we get information about the investment regimes that you both spoke about, the draft code in the case of CARICOM, or these are kinds of questions that keep coming up, is access to information. One of the questions also is, how are we ensuring complementarity between all these agreements? And whilst, Kholo, I agree with you that CARICOM seems to have at least, penned a code. CARICOM is 13 countries, or 15. Africa, as we heard, is 54 with 8 recs. So not to give, you know, not to sort of dismiss that accolade to CARICOM, but I think we're dealing with also many more sort of frameworks to reconcile. And then I think we have a question from Time Moon, which is really to Chantal, but I think it can equally be put to Makane, which is this idea about, in the context of discussions between the EU and China, in the context of their investment agreements, typically an investment agreement, concerns that the Chinese companies, especially those that are investing in Europe, are actually able to compete unfairly with European firms because of the government subsidies that are being provided to state-owned enterprises and other Chinese firms. And the question is, there's been a proposal in the EU which would allow the Commission to investigate foreign direct investment above a certain threshold for subsidies. And I think later on in her questions, she added that in the EU context, of course, there's this kind of very developed state aid rule regime. Do we have similar things happening in CARICOM, especially at the level of regulation of subsidies? Even internally, far less how we deal with subsidized firms coming and playing in our region and therefore getting a leg up. I just wanted to and I see one more question from BC, and I'll leave that for because we have 8 minutes. Do you think Africanization, the thesis, may influence broader ISDS reforms beyond the current sustainable development provisions? So I think there's a lot to choose from. My question, Kolo's question, the ones I just read out, but I'll leave it to the experts to, in the next 8 minutes, deal with them as they'd like. So I'll stop here and then ask Chantal maybe to start.
Okay, thanks, Jan. Lots of very interesting points and questions. I'm just going to pick out things as I recall them being mentioned. To John's question about whether there's an adequate emphasis on smaller investors or if we're just focusing on the big multinationals, the short answer is no, we're not just focusing on the big multinationals. The governance regimes that I mentioned, particularly those that are based on equal treatment of domestic and foreign investors, is the antithesis of that kind of approach. It's about leveling the playing field for all participants in the market. And as I mentioned, there are domestic laws in the region that actually are oriented towards that approach. In terms of the community's investment policy, while I have been stressing the code, what is being developed is a community investment policy framework. And that community investment policy framework recognizes the importance that the diaspora, for instance, has to play in boosting investment opportunities. So the short answer I have to that question is the orientation is not to focus from a governance point of view on only protecting or prioritizing or elevating protections that are afforded to larger investors. In terms, there's a question that arose about how did CARICOM develop this common view? There's convergence to a point, but there's not total convergence. I do think that what has contributed to there being maybe greater, but by no means total convergence is the absence of competing arrangements within the region. As I mentioned, intra-regionally, the main framework that governs investment from a treaty point of view is the 2 regional economic integration arrangements that I mentioned, and they're going very much in the same direction in terms of what they're guaranteeing. So I don't think our starting point was the same in terms of contending with as much fragmentation as Makane depicted. I think that's one point. I do think as well that CARICOM as a customs union negotiates external trade arrangements jointly. And I think that joint negotiation of external arrangements has contributed as well to greater convergence in terms of the orientation as to how investment discipline should be formulated. I didn't have time to mention this, but after our experience negotiating with negotiating an investment chapter in a comprehensive trade agreement, those negotiations were suspended. We took the opportunity to try and develop model text that would represent our starting point for negotiation of investment chapters in external trade agreements. And we were drawing inspiration from multiple sources, including some of the sources which Makane mentioned, like the Commissar Arrangement, the SADC Protocol, for instance. He is totally right that in our work on the investment code, we have been looking at developments like the PIKE. And so I think that joint negotiation of external trade agreements, which increasingly are covering investment, has contributed to that as well. I do want to briefly just touch on the question about information about, I'm going to zone in on, I think, the question that John was raising relating to access to information about regimes under development as opposed to established regimes. And I do agree that there could be greater transparency. I'm just going to leave it there. There could be greater transparency. There ought to be more transparency. In terms of complementarity between agreements, the only point I want to make here is, and this, you know, it came out so strongly when Makane was speaking, there must be coherence in investment governance. That's why I talked about the approach to what you put in contracts, what you have in your domestic laws, what you have in your existing treaties, what you're negotiating in future treaties. If these various regimes are treated as distinct and separate, you will have fragmentation. And that's why I'm urging there be more attention to the different ways in which investment is governed. It's not just a treaty. It's not just the regional treaty. It's not just, you know, we have to look at this coherently so that the outcomes that Makane identified of intra-regional investment being treated one way, investment with external partners being treated another way, contracts being concluded that, no, there must be coherence. And then finally, to Taimoon's question, there is no current regime governing state aid in CARICOM as yet, but it's on the agenda with respect to development of competition policy. Thanks.
So if I can, I see that there's only 2-3 minutes remaining, but just to jump quickly on transparency, definitely, you know, I've been insisting a lot, you know, towards the negotiators that of the future investment protocol, that we are living now in an era of transparency. People need to know what's going on. People should be even able to comment on draft text, you know. It doesn't make sense till today that we are in hidden rooms negotiating and nobody see the text. So we even need to foster public participation, and efforts are being made at that level. I know that the African Union, the FCFTA Secretariat has planned to have several regional rounds, you know, where actually, you know, private companies, academic, civil society will be invited in order to be better informed on what the negotiation process of the investment protocol will be about. But we really need to foster, you know, a rhetoric of transparency and public participation in the investment regime. So I agree with that. We are making a lot of efforts. I mean, for those who are interested in publications regarding Africa, drop me an email and I will send you, you know, I will orient you toward links that will give you a lot of publications, you know, where people like me and some other colleagues, brothers, sisters have been doing a lot of work on the investment regime in Africa. Just to jump quickly on Kholo's question regarding, you know, what should be the proper format. You know, I agree with you. You know, I think one of the major problems of the investment regime is that all of us, we see the investment regime in a top-down approach. It's always top-down. We don't think about developing bottom-up approaches in investment regimes. So, you know, I don't think that coming with a very stringent, restrictive future African investment protocol will work. We need to think about something that looks more like a framework with guiding principles and so on, and then push for member states to then, you know, develop bottom-up approaches to align their investment legislation, their bilateral investment treaties, the regional investment instruments, etc. We need to think more in terms of bottom-up approaches and create a paradigm shift, stop thinking about the top-down approach when it comes to the investment regime. And then there was a last question from my brother and colleague Olabizi regarding the Africanization of ISDS. I think it's provoking me. It's provoking me because he knows that what we have been successful to do was substantive Africanization, but we were never able to come with a strong African voice when it comes to ISDS. The reason why the Pan-African Investment Code actually failed is because we were not able to agree on ISDS. That was the only provision in brackets, and that's why it just became a model. So this is one big challenge. How do we build Africanization when it comes to ISDS? I will let my brothers think about, the ways out. Thank you very much.
Kolo, are you going to close?
Oh, I thought you wanted to say something. Thank you so much to you, Chantal and Makane, for really amazing interventions and just thinking about investment in sort of such a broad way, but also bringing home the point that it's all about what governments need today, and going back to the old generation is not the way forward. So really, we're looking forward to the new developments in the Caribbean and also in the AFCFTA, because it's going to be exciting to see what eventually comes out of all of these negotiations. So thank you to our participants. Thank you so much for your thought-provoking questions. And we hope to see you next week, Thursday, for the next and the final webinar on dispute settlement regimes in the Caribbean and in Africa. Thanks a lot. Have a good evening.